My name is Helene. I am a South African lawyer and journalist, and I have been looking into all things lockdown and legal over the past 2 months. We had a wonderful decision in the Pretoria High Court yesterday where level 3 and 4 lockdown regulations were declared unconstitutional and invalid. The purpose of this video is to speak to you in everyday language about the judgment and explain what it's all about. I always also want to highlight some wonderful statements that was made by the judge and that acknowledged the plight of everyday South Africans, such as hairdressers and mothers, grandmothers who take care of their children, and the dramatic effect that the lockdown has had on these people. We're going to start with the order, paragraph 1 of the order, which states that the regulations promulgated by the Minister of Kogta in terms of the Disaster Management Act are declared unconstitutional and invalid. In paragraph 2 of the order, you will see that this declaration of invalidity has been suspended for 2 weeks. In other words, the current lockdown regulations, it's now June 3, will remain for the next 2 weeks and will all be bound by them. Meanwhile, Kogta will have a fortnight to amend the regulations in order to render them constitutionally justifiable. In addition to that, and I'm reading from the judgment, we see that the regulations pertaining to the prohibition on the sale of tobacco and related products is excluded from this order. In other words, the anti-tobacco lockdown regulations were not declared unconstitutional and invalid, and the judge explained the reason for this is that the court will deal with this in another case that has already been scheduled. Regarding costs, the minister has been ordered to pay the costs of the first and second applicants. And that brings me to the parties to this court case, who was responsible for it. The applicants, and those are, in other words, the people who went to court and said, we don't think these lockdown regulations are valid. They are Reino David de Beer, the Liberty Fighters Network, and the Hollabon Renaissance Foundation, which was added as a friend of the court, and they have to pay their own legal costs. And the application was brought against the Minister of Cooperative Governance and Traditional Affairs. So the applicants said that the lockdown regulations don't make sense and that they are irrational and not justifiable. I'm going to read through some parts of the judgment in addressing that issue. Now, Judge Davis said that we need to consider, in order to consider the rationality of the lockdown regulations, we need to weigh up on the one hand the purpose of the regulations, which is to curb the COVID-19 infection from spreading. So we have that purpose on the one hand, and then we have the way in which government tries to get towards that purpose, which has many limitations. South Africans have been complaining for a very long time that they can no longer earn an income under the regulations, that the personal movements are restricted too much. Hairdressers is one category of people who were prejudiced by these regulations to an extent that I think many of us can't even understand. They are really, really suffering. And the question in this court case was, is all the suffering and all the negative consequences of these strict regulations really worth it? Of course, keeping South Africans alive and safe is important, and the judge acknowledged that in the judgment, in paragraph 5 specifically. But he then went on to say that Section 36 of the Constitution is instrumental here, and the crux of the matter is to look at, one, what are the effects of these limitations, and how does it step onto our constitutional rights? How does it infringe on our constitutional rights? And is that justifiable, considering what we're trying to do with these regulations, which is to keep the infection from spreading, which, as we know, is not going to happen because we already have many people who are ill, and the infection figures have been rising despite government's efforts. Now, part 7 of this judgment is really, really special and important. It explains how the lockdown regulations have affected everyday South Africans. And Judge Davis set it out really nicely. And I'm going to read it to you because I believe many of you will feel that you can resonate with the examples that he listed. In paragraph 7.2, he says, there are numerous thousands, no millions of South Africans who operate in the informal sector. There are traders, fisheries, shore foragers, construction workers, street vendors, waste pickers, hairdressers, and the like who have lost their livelihood and their right to make a living as a result of the regulations. He also said that the blanket ban imposed on them, as opposed to the imposition of limitations and precautions that could have been less limiting, appear to be irrational. To illustrate the irrationality further, he cites the case of South Africa's hairdressers, and that is in paragraph 5.3. A single mother and sole provider for her family may have been prepared to comply with all the preventative measures proposed in the draft Alert Level 3 regulations, but now she must watch her children go hungry while witnessing minicab taxis pass with passengers in a closer proximity to one another than she would have been to her client. Does this make sense? Is this fair? And the judge finds that it does not seem to be. It strips the hairdresser of her right to dignity and equality, her right to earn a living and to provide for the best interests of her children. In paragraph 7.5, he states that there are random other regulations regarding funerals that don't really make sense. One of them is that there needs to be a degree of family relationship between the person who died and the person who goes to the funeral. And aside for familiar and other relationships that will allow you to go to a funeral, you might miss out on a funeral of someone you really cared about based on the regulations. He questions whether this is justifiable and finds that it is not. Restricting the right to freedom of movement is addressed in paragraph 7.8 of the judgment. Doing this in order to limit contact with others, in order to curtail the risks of spreading the virus, is rational, but to restrict the hours of exercise to be arbitrarily determined is irrational. In paragraph 7.9, he lists another example, and I quote, "Similar, to put it bluntly, it can hardly be argued that it is rational to allow scores of people to run on the promenade, but were one to step foot on the beach, it will lead to rampant infection." The line of argument, as he points out, does not make sense. And what about the poor gogo, Judge Davis asks, who had to look after 4 youngsters in a single-room shack during the whole lockdown period? She may still not take them to the park, even if they all wear masks and avoid other people altogether. He then states in paragraph 7.11 that even if government's attempts at providing economic relief functions, as we know it does to a certain extent, many South Africans have applied for economic relief from government or have benefited from it. And unfortunately, many of these application platforms do not work, and there has been a disappointing amount of silence from government or lack of action in this regard. However, taken into consideration the fact that you can still claim money from government and you can successfully do so, the judge points out that no amount of money can provide relief when compared to the human rights violations that South Africans have been suffering as a result of the lockdown regulations. He then highlights food parcel distribution and the practical issues that we're dealing with here. A whole community might have had limited contact with one another, he says, and they only would pass to school or work and for basic necessities. Now all of them must stand in a row to get a food parcel. In the greater context of things, this also does not really make sense. In paragraph 7.13, Judge Davis says that there are many more instances of sheer irrationality included in the regulations. And he says one need only think of the irrationality in being allowed to buy a jersey but not undergarments, or open-toed shoes, and the criminalization of many of these regulatory measures. Despite all these rationality failures, he states, as we stressed when reading the order, that regulations 36, 38, 39 sub 2 D and E and 41 appear to be rational and therefore do not have to be amended. I'm quickly going to look into those so that you know which regulations won't be changed. Section 36, that is the section dealing with the prohibition on evictions, so that will remain. Section 38 prohibits initiation practices during lockdown. That prohibition will remain. Places and premises closed to the public, there's a specific section that will remain, which is that nightclubs and casinos will remain out of bounds for the lockdown period. Closures of borders will also remain as is. Judge Davis's judgment was welcomed by the South African public, many of who felt that they could no longer handle these regulations that they felt were really impacting their basic human rights to an unjustifiable extent, as the judge explained. So we will see in 2 weeks what the new regulations will look like. In the meantime, please adhere to the current regulations to avoid getting in trouble.